All right, everyone, we will be getting started in a couple minutes, so just hang tight. All right, everyone. Well, let's get started. I wanted to say thank you for coming. So my name is Catherine Holm, and I am the Legal Counsel and Legislative Manager for Washington Food Industry Association. Today, what we will be talking about is the Equal Pay Opportunity Act, or what we have called throughout session the Equal Pay Act. I would like to introduce Ellen Saline. She is an industrial relations agent with LNI. So go ahead, Ellen.
Yes, thank you for having me. As Catherine said, my name is Ellen Saline, and I'm an industrial relations agent here at the Department of Labor and Industries. And part of my duties are to investigate Equal Pay Opportunity Act complaints. And I'm here to talk to you guys a little bit more about the law. Okay. So as you may be aware, during the 2018 legislative session, the state legislature passed Second Substitute House Bill 1506, which was then codified as RCW 49.58. And this law is known as the Equal Pay Opportunity Act. And this law updates an existing law, which went into effect in 1943, and that's the Equal Pay Act. And the new law addresses income disparities, employer discrimination, retaliation practices, and it provides equal protections under the law to all workers regardless of gender in Washington state. And this law went into effect on June 7th of 2018, so it's a pretty new law that is on the books now. So there is a federal law that also pertains to pay equity. And people might ask, if there's a federal law, why does Washington state need another law? But there are some differences between the two. The Federal Equal Pay Act of 1963 applies to pay equity for men and women only. It does not require equal advancement opportunities, and it does not provide protections for employees engaging in wage discussions. And that differs from the Equal Pay Opportunity Act of 2018, which applies to pay equity regardless of gender, requires equal advancement opportunities regardless of gender, and it provides protections for employees engaging in wage discussions. And I'll also note that the Federal Equal Pay Act is enforced by the EEOC, and that is the Equal Employment Opportunity Commission. Under the state law, any employer who discriminates in any way by providing compensation based on gender between similarly employed employees is guilty of a misdemeanor. Discrimination could be described more broadly as the practice of treating one person or group of people less fairly or less well than other people or groups. So when we're talking about compensation, compensation includes discretionary and non-discretionary wages and benefits. So this includes employee salaries, but also pertains to things such as bonuses, insurance, vacation, retirement plans, or other benefits. Under the law, employees are similarly employed if they work for the same employer and the performance of the job requires similar skill, similar effort, similar responsibility, and similar working conditions. And it's important to note that job titles alone do not determine if employees are similarly employed. So we really need to evaluate what duties and responsibilities the employees have, not just similar job titles. So really comparing that skill, effort, responsibility, and working conditions when evaluating whether employees are considered similarly employed. So there are circumstances where people of different genders who are similarly employed may be paid differently. And compensation differences that are based in good faith on a bona fide job-related factor could be considered non-discriminatory if they are consistent with business necessity, not based on gender, and account for the entire difference. And these bona fide factors could include things such as education, training, or experience, a seniority system, a merit system, a system measuring earnings by quantity or quality, or regional differences in compensation levels. So there are instances where people of different genders who are similarly employed may be paid differently. Compensation differences could be considered non-discriminatory if they are based in good faith on a local government ordinance providing for a minimum wage different from state law. For example, this would apply to an employer who has locations in 2 cities with different minimum wages. An individual's previous wage or salary history is not considered a defense for a compensation disparity between genders of similarly employed employees. So it is not acceptable to pay people of different genders differently based on what they've made in previous positions. Burden of proof for defenses. Employers carry the burden of proof for defenses of compensation disparity between different genders that are similarly employed. In other words, if a complaint is filed and an investigation is initiated, it is up to the employer to provide evidence that pay differentials are based on factors other than gender. Advancement opportunities. Under the Equal Pay Opportunity Act, an employer may not, on the basis of gender, limit or deprive an employee of career advancement opportunities that would otherwise be available. So examples of this could be promotions or training, etc. Now, similar to pay equity, a differential in career advancement based on a bona fide job-related factor does not constitute discrimination. Again, bona fide job-related factors could include education, training, experience, and seniority. Non-disclosure of wages. So there's also protections under the Equal Pay Opportunity Act that state that employers may not require non-disclosure of an employee's wages as a condition of employment. So in other words, employees have the right to engage in wage discussions with coworkers. And the reason for this is if employees aren't allowed to discuss their wages, they may not know that gender pay inequity exists. Signing waivers. Employers cannot require employees to sign waivers or other documents that prevent them from disclosing their wages. An example of this might be a non-disclosure agreement that prohibits wage discussions. So in other words, employers cannot force employees to waive their right to engage in wage discussions. An employer may not discharge or in any other manner retaliate against an employee for inquiring about, disclosing, comparing, or otherwise discussing their wages or the wages of another employee. Asking the employer to provide a reason for their wages or lack of opportunity for advancement, or aiding or encouraging an employee to exercise their rights under the law. Employers may prohibit employees who have access to compensation information as part of their essential job function from disclosing wages of other employees. So for example, human resources employees may have access to know what other coworkers' salaries are, and employers can prohibit those individuals from disclosing the wages of other employees, but not their own wages. Employees are not required to disclose their compensation, so the law provides the right but not the requirement. For example, if a coworker asks you what your wages are, you're not required to provide that information, but if you want to share your salary, you are able to do so. An employer may not retaliate, discharge, or otherwise discriminate against an employee because the employee has filed a complaint or exercised any of their rights under the Equal Pay Opportunity Act. So those rights, again, that we've been talking about are asking for a reason for their wages, or asking for a reason for their lack of opportunity, advancement opportunities, engaging in wage discussions, or filing a complaint, or encouraging a coworker to exercise their rights under the law. So if an employee files a complaint with Department of Labor and Industries, L&I must investigate that complaint. And through the process of the investigation, L&I may require the testimony of witnesses and production of documents as part of an investigation. And as we discussed, the burden of proof in these cases is on the employer. So it would be in the employer's best interest to provide documentation that would show the reason for the, for example, pay inequity. And under the law, L&I, upon complaint, may also initiate an investigation on behalf of one or more employees. After investigation, if L&I determines that a violation occurred, L&I shall attempt to resolve the violation by conference and conciliation. And that's written into the law itself. And the purpose of conciliation is to try to resolve the complaint without the department issuing a citation and notice of assessment, and trying to do an alternative settlement resolution. If a resolution is not agreed upon by both parties during the conciliation process, L&I may issue a citation and notice of assessment and order the employer to pay the complainant damages. L&I may order the employer to pay actual damages, statutory damages, which are equal to the actual damages, or $5,000, whichever is greater, interest of 1% per month on compensation owed, costs involved for investigation and enforcement, and a civil penalty of $500 for a first violation and $1,000 or 10% of damages for repeat violations, whichever is greater. And those specifics are all outlined in the law itself. Any wages and interest owed must be calculated from 4 years from the last violation before the complaint. L&I cannot go back prior to the effective date of the law to assess wages or interest. So since this is a new law that went into effect on June 7th of 2018, we are unable to enforce the law before it went into effect. So we, for example, would not go for back wages prior to June 7th of 2018. If a citation and notice of assessment is given to an employer, employers may appeal the citation and notice of assessment, and those appeal rights will be provided with the citations and notice of assessment. Under the law, an employee may also bring a civil action against an employer within 3 years of the date of the alleged violation. If this occurs, filing a civil action shall terminate L&I's processing of the complaint. So if L&I has initiated an investigation And while the investigation is still open, a complainant files civil action, the department will close its investigation. We no longer have jurisdiction at that point. So I know that was kind of a lot of information in a short amount of time. So I want to open it up for questions and try and clarify anything that may be lingering out there.
Ellen, this is Jan G.
Hi, Jan.
Hi. Thanks for being with us today. One of my questions is came up on the floor debate with the legislature. If an employer pays for a female employee to go to an employment training course that is for women, you know, you see these at, you know, women in management or, you know, different kinds of courses like that. Is that any longer allowed under this equal pay law?
Okay. I'm just making a note of the question. So, like I mentioned, this is a new law that went into effect, and those are some of the questions that, you know, working through with the Assistant Attorney General's office and trying to make a determination in such cases. I don't have an answer for you in this moment on that specifically, but I would be happy to follow up with you and see if I can provide some additional information.
That'd be great. Thanks, Ellen.
Okay. Yep, no problem.
Do we have any other questions?
You can also type your questions in. Is there a question typed in there, Kat? It looks like it.
There is, but it wasn't about the actual.
Oh, okay. Ellen, what other kinds of questions have come up from employers to the department as they're trying to implement this?
You know, we're very early on in our outreach efforts. I will mention that there's more information. We have information on our website, which includes our fact sheets and the complaint form. So if employees wish to file a complaint, they can find our complaint form online as well. And the website is lni.wa.gov/equal-pay. So that has some additional resources there as well if there's follow-up questions. And again, my contact information was at the beginning of the presentation, and I'm happy to answer phone calls or emails with questions that come up maybe after the presentation.
So I have a question. This is from Avis, and it says, how does one determine what is equal responsibility if they are different?
That's going to be a very case-by-case basis. It will depend, you know, each case will be unique, and the facts will need to be evaluated individually. I don't have a broad answer that can apply to every situation, because each employee's job duties and responsibilities will be unique, and it will, you know, those will need to be taken into consideration.
And then there's a follow-up question that says, how do we monitor that? So I guess my question with that is, are you asking how do we monitor the complaint, or how do we monitor the different responsibilities?
I guess I'll just speak broadly if there's not any, did you get clarification?
Yeah, hold on, okay. Sorry. How do we keep breaking the law if we are unsure if the responsibilities are considered equal?
Well, I'll try and answer that the best I can, make sure I'm understanding. I think, it would be prudent for employers to start looking at employees in their organizations and comparing job duties, which include to see, are there positions that may have different job titles, but they require the same skill and training? Are there positions with different job titles that require the same amount of experience to get the position, or are there measurable goals within these positions that look comparable? And making those type of determinations to see if the positions, while on paper may have different titles, but do they require those same skills, efforts, responsibilities? Do they have the same number of direct reports? Do they have similar working conditions? And trying to make the determination that way.
So, Ellen, I'm assuming that as our members are going through this with this new law in mind, if they have a situation that's in their workplace that they're not sure if it is still legal or not, that they could submit the question to you in writing, or if they prefer to be anonymous, submit to you for a written response.
Yeah, we're here absolutely to try and help provide any information or guidance we can. Again, it'll be very case-by-case basis. So if there's specific questions that come up, we'd be happy to try and get those answered.
Great.
And just by curiosity, since this law went into place, how many individuals have filed with Labor and Industry?
We've had a number of cases, complaints submitted. I'm going to be totally honest. I'm not sure if I'm allowed to disclose that information or not. So if I'm able to, I can follow up with you. I just would prefer to run that by my program manager.
I know that we were told the amount, I think sometime in June, like right after it came out, but.
Yeah, like I said, I'm happy to provide that information if that's the standard procedure. I just would not like to make that determination without speaking to the department.
No, that definitely makes sense.
Well, it sounds like people are satisfied with the information, at least to date, and Kat is there at the office to assist you with clarification on any part of this, and she'll interface with Ellen, and Ellen's very good about returning the phone calls and trying to help us get all these clarifications. So good job, Kat, and our Educational Foundation for having this, and Ellen.
Thank
Ellen,
you for
there's
having
two
me.
other questions that just came in. Nolan has asked, does this apply to government jobs as well, or are they exempt?
It does apply to government jobs as well.
And then there was another one that says, do guidelines exist for how the seniority or merit system should be structured, or is that going to be a case-by-case determination?
That will also be case-by-case basis. There's not a specific split to follow.
Of course, all of this information will be published on our website if anyone hasn't been able to join us. And
Okay, are we done?
I think so. Thank you so much for presenting and joining us today. And
You're
great
welcome.
job,
Thank you
Kathy.
for having me.
Thank you, Ellen.
Thank you.
Thank you, Ellen.
Have a great day, everyone.
Yes, you too.